Hey, welcome back. You have Michael Gullo and Christina O'Shea, my partner, and we're here doing EUOs. And we're part two here. Gonna jump into section four of our training module. And this is the no-show or the appearance at the EUO, our favorite part. Share my screen. So the EUOs, obviously, they're either going to be a no-show, which is they don't show up twice, or they do appear. Like we spoke about earlier, reasonable requests for adjournments, they're going to be granted. Professional courtesies are going to be granted if it's reasonable. We won't give a month or 6 weeks so that they can treat for another 6 weeks. We will give a short adjournment, maybe a week or a few days. We will modify the time to the best that we can. There's a lot of juggling with that, especially when there's multiple claimants and different attorneys. However, that will generally be granted. So a no-show, two consecutive no-shows. There is zero contact. We send the letters. Let's assume there's no attorney. Letters go out to all the last known addresses and no one responds. That's two consecutive no-shows. Sometimes it can get a little tricky as start requesting adjournments, and then we had one where the claimant appears, the attorney doesn't appear, then they need another adjournment. So we really try to keep track of the scheduling so that there's a chronological history that we can use later when we need to deny the claim for their non-appearance or non-cooperation.
Right. And there is some subjective judgment that goes into what we would consider or see a judge to consider a no-show at that juncture. For example, if the first time they didn't show up, but the second time they called and said, "Oh, well, my client is sick," we want to
Right.
show that reasonableness on our end and not just say, "Well, too bad." However, if they do it the morning of, which we've seen, we always like to put a statement on the record anyway, just to preserve that. And in those instances, we always keep the adjusters involved. We let them obviously be the ones to
Right.
decide really
Right.
what they want to do. I think that's helpful for everybody to be on the same page in every turn.
And again, to consistently throughout this EUO process, documentation, it really needs to be perfect. Not a little okay, not okay, not a B plus. It needs to be perfect. Um, let's assume we scheduled them properly. We did everything timely. They don't show up for two consecutive appearances. Post appearance, we want some type of reporting. Generally, on a no-show, it'll be a simple email exchange with the SIU rep or the adjuster. They didn't show up, and we follow for transcripts of the non-appearance where we appear before the reporter and we say that the person didn't appear. Here's an example of what it may look like. There's a statement on the record made before the reporter. In this particular case, it looks like it was I who appeared. So my name is Michael Gullo. I appeared. This person was supposed to appear at 9 o'clock. We've been here since 8:50. The time's now 9:45. Nobody showed, nobody called. And generally the reporter, this one is not signed because this is just a form, but generally the reporter will sign this document. In addition, this can be used as proof of their no-show. In addition to this, what we generally do in our summary judgment motions is whoever the attorney is that appeared will likely be the one drafting the summary judgment motion so that we can say, I am Michael Gullo. I appeared at the EUO. That is my recorded statement and transcribed properly. I was there personally. They didn't show up. So
And
there's,
also in those,
yeah,
yeah, and then in those, just to piggyback off what you're saying, in those no-show statements, one, we're very sure to allot that 30, at least 30-minute period for them to show up late if they,
right,
and typically they don't wind up showing up. If they're not
right,
going to show, if they're not there 10 minutes, and they usually don't. However, sometimes it happens. And so we do make sure that we are very careful about putting that statement on the record only after a minimum of 30 minutes of waiting. The other thing we like to do is be very thorough in terms of the fact or listing the fact that they did not inform our office that they would be late. They did not inform our office that they could not appear. If there is a history of non-appearance, we like to include that within the second statement. So for
Right.
example, if this is the second no-show,
Hmm.
we like to be very thorough and put the date and time that they were supposed to appear at the first time, where they also failed to appear, just to establish a pattern of non-appearance. We don't like to, we like these documents to complement one another and not just be individual documents. It should be a document that's built off of. So that history is important to include. Would you agree with that, Mike?
100%. The history is critical, and we include it in the statements if to just to show the history, so we can show the chronological events, so everything's tight and
Right.
done the right way. And that goes into here our affidavit of mailing, proof of the no-show, affidavit of mailings of the scheduling letters, proof of the no-shows, is again that statement on the record and our affirmations and affidavits in support of our motions. That takes us through the no-show for the claims rep or the adjuster or the SIU rep. You want to have your scheduling letters. You want to have your no-show statements so that you can use them or refer them to defense counsel when it comes time to defend on the litigation, no fault end and no fault litigation arbitrations. The other scenario that could happen is that they actually appear. When they do appear, few steps to take place. We confirm with the court reporter. We confirm with an interpreter or whether one is necessary. All the parties need to be confirmed, and we confirm with the attorneys. Generally, if it's an attorney, there'll be an email exchange and they'll ask for the link, even though it's in the letter. We'll send them that. So this way, everybody's on the same page. What during the EUO, your attorneys will take notes. And our notes are not the transcript, but it's a first early indication of the questions we're asking, the answers we're getting, giving a history and an overview of the claim, going into the medical specialties in detail. And this should all be included in the attorney's report so that early decisions can be made. Background, we included a non exclusive list. So this includes some of the more common things that we would be asking or questions that we're sure to cover at the EUO. And of course, SIU, when they send referrals, often will say, hey, can you ask this? Or, keep particular eye on this. Or the accident was only 2 days after inception and they had 8 people in the car, let's address that. So,
Right.
and before these EUOs, what we like to do is have contact with the SIU reps to have a conversation about the case, make sure we're all on the same page on the claim, and what we're actually looking for and why we're doing the EUO in the first place.
Right. And I think stylistically, because we've seen countless attorneys conduct them, um, what we like to do as attorneys is definitely have that conference call with the SIU. We're provided with a lot of information, an ISO report, sometimes address discrepancies or policy inception dates are a little too soon to the time of the accident, or the policy was canceled right after it. So there's a lot to pay attention to, and it's easy enough for an attorney to just get that information and run with it. But I think what we prefer to do is have that one-on-one conversation with them and just make sure that we're getting them the information that they are looking for. And sometimes we'll even take, Mike and I usually sometimes for the bigger ones, we'll piggyback off of each other and tag team a little bit.
Yes.
I think that's helpful because we're seeing different things, right? And sometimes we'll even take a break in the middle of the EUO and conference the SIU back in and say, hey, this is what we have so far. Is there anything else that we need? I think that open line of communication, especially even while as silly as it sounds,
Mhm.
while the examination is going on, I think that's tremendous.
And getting this all down into a proper report is important for the early decision making. And the reports include recommendations, things that we've discussed with the SIU, things that we say, okay, maybe we need to do an IME, maybe we should, peer review these EMGs because they only got it a week after the accident, further investigation that we might be looking into when there are multiple occupants in the vehicle, relating their stories, where the inconsistencies lie. These are all things that we go into our reporting so that when we get transcripts in, we confirm these things so that we can move forward with the claim, either denying it or verifying it in another way.
Right. And while we're thorough in the report, we also boil it down because the transcript is full of tons of information. I mean, you can
Right.
conduct
Well, an adjuster,
graph.
they don't want to be reading 10-page reports. We
Some
should be
adjusters
able
might
to
like
sum
that.
it down to probably 3 or 4 pages. We should be able to nutshell it, unless there's an issue that requires more development.
Right. And it's, just to what Mike was saying in terms of the occupants within the vehicle, we also like to see the relationships, the personal relationships between these individuals, how they came to be about in the same car at the same time. Sometimes those stories don't even line up. Well, I knew so and so for 10 years. The other one says, well, I just met him last week. Those are
Right.
red flags. Those are
Yeah.
things that you definitely want to pay attention to, is just even the interpersonal relationships of those individuals. There's a reason why you were all in the same vehicle allegedly at the same time, right?
Yeah.
So,
And I mean, we have a script that generally, I mean, any good attorney will have some type of a script that they want to work off of to make sure they cover everything. This list is not a script per se, just some of the parts that we hit. We are our training for doing these EUOs and the way that we work and we keep an eye on each other is not to follow the script to the letter. Sometimes you'll get people who just follow the script and ask completely irrelevant questions only because it's on the script. We shy away from that and try and get to the meat of actually what we're looking for.
well, you can't really stick to a, I mean, again, this is a stylistic preference, but I feel like you cannot stick to a script completely because oftentimes you'll get information that you didn't expect to get. And so
Right.
you have to know how to pivot and what questions or what path to go down based on that new information, right? Oftentimes we're hit with information that we were not aware of if we're asking the right questions.
Yeah. And when we're asking these questions and we're going through these EUOs, a lot of times we will state the obvious and have them agree. But, we want to be careful how you phrase questions because if you ask anybody, a question, oh, did you get hurt in the accident? The answer is always going to be yes. So there are stylistic ways to get to the truth and get to the bottom of it. I mean, ultimately, at the end of the day, that's what we're looking to do. We do see with staged accidents a lot of times they have their stories pretty good because the accidents actually happened, but they staged them. So they're breaking down those relationships. Again, here, pre-accident details, body movements, what parts of their body. And it's a chronology of events. When we say post-accident chronology, pre-accident, it's basically taking the claimant from the time they woke up that day up to the time they went to bed and then following for treatment, what they did and try and get those details out of them.
Right. And that's also a crucial element of why getting these EUOs scheduled as close to the accident as you can is so important
Right.
because those are details that you want them to remember. I woke up at such and such time and I met so and so at 10 o'clock. We want them to remember those things because the more they give us, the more we have our hat to hang on in terms of, well, if somebody else doesn't follow through with the same exact story, then there's a problem,
And
right?
even details on how they made plans that day. So, oh, he picked me up at 10 o'clock. Okay. When did you decide you were going to make the arrangement to be picked up? When did you have that conversation? Was it through a phone call? Was it through a text message? Trying to get those details so that when we speak to the other person, we ask him the same question. What were the details? Was it a phone call or text message? A lot of times on these details, they just make it up as they go. It won't be consistent. If it's real, then it will be consistent.
And the other thing is to pay attention to, I guess from our end, when we're asking these questions, if we're not really dealing with fraud, but we're dealing with maybe provider involvement or improper treatment or excessive injuries,
Mhm.
the better attorneys on the other end will focus on what questions were being asked of their client. And so, for example, if we ask them, well, did you have an EMG NCV? There's not many people, or the layperson might not understand that. And so if we are not then following up with an explanation, sometimes we've seen those questions, if they're dead end questions, if we ask a
Right,
question about something that they don't know what it is necessarily, or may not know what it is, and they give
right.
us a no, and we check off that box, That's not enough. We have to
Right.
explain to them. We're asking them, well, do you know what an EMG NCV is? We're well versed in it that we can probably explain just as much as a doctor could at this point. Mike, would you agree with that? And so
Yeah,
it's
I
important
look,
to explain those things.
yeah, our knowledge, I mean, of the anatomy, so to speak, and the testing has to be on a high level. I mean, we need to know this stuff and what it is. But yes, asking details about the testings is important because they might not know if there was a needle, was it reinserted, was the EMG inserted under the skin? What did it feel like? Did someone come in and were they just sitting there that day? Getting those details, even on the MRIs, making sure they actually got in the machine. Some
Right,
people will tell you that they got an MRI. Yeah, what's it look like? And they have no idea.
right.
So, making
You know,
sure that each of those modalities, like, I mean, if we go down here, let's see, a modality, different types of modalities, hospital, the acupuncture, did they have reinsertion? Did they not have reinsertion?
well, we
Things,
also like to see the time. Well, how long did that take? Or how long did physical therapy take?
absolutely.
Or the details of the treatment? Because those things are crucial when we are then deciding, or the insurance carrier is then deciding, well, I have received a bill for 45 minutes of a PT session.
Right.
And now we have an EUO stating I was only in the PT for 5 minutes. That's a problem. And so
Yes.
that's enough to deny. But if
And
our
that,
questioning is not thorough enough, you have a harder time denying that.
yeah, and that's common with the psych evaluations. It's they'll bill you for 8 hours, and the person at the EUO says, "Oh, it was a 5 minute or 15-minute session." And
Right.
this way, and it's okay. It's common with the DMEs, the medical supplies. Which ones did they get? Did they get instructions? Were they fitted for the LSO? Or did they just get a random one? What are we getting billed for? We do see a lot of diagnostic tests where the people say they didn't get the testing, and we get bills for them. So that's the type of thing in our recommendation portion, we will say if you get a bill for, an EMG, they definitely never got one, so deny that.
Right. Or even like you said with the psych evaluation, sometimes if we have that information going into it, which is again, I will reiterate the fact that it's so important to give us everything you have before we go into an EUO.
Mm,
If, for example, we see a psych evaluation for 8 hours, which is unfortunately not uncommon,
right,
we like to ask them, did you suffer any mental anguish from this accident?
right,
Well, no, what are you talking about? We'll go through stress, anxiety, suffering, not able to sleep. And if they say no to all of this, then we have a reason to ask, well, why were they even sent for this psych evaluation in the first place,
right.
right? And
Lack
there's
of medical necessity. There you
right,
go.
and there's a lot that ties into all of that.
Yeah. So we could go into, there is definitely a lot more detail in the actual conducting of the examination under oath and the questioning and the modalities. This is just a basic overview to touch upon the types of things that the attorney should be asking and that we should be reported on.
We also like to either show them as an exhibit their NF2 or at least have it pulled up on our end while we're doing the questioning, because even down to sometimes we'll see claimants list the body parts that were allegedly injured and they don't match up with what's listed on their NF2. And again, that's another red flag. That's a problem. We'll ask them specifically, well, is there a reason why you didn't list your left shoulder when you listed your left shoulder on the NF2? Well, what's an
Yeah,
NF2? I was never shown this form, right? And so it opens up this whole Pandora's box of you want to make sure that all these documents really are working off of each other. We want to be aware of everything.
agreed. So after the EUO is completed, within 24 to 48 hours, you should be getting a report from the attorney who appeared, and then we follow for transcripts. Get transcripts can take some time. Having good relationships with the vendors helps because generally speaking, I think SIU likes to get their transcripts as quickly as possible because they're on a tight time frame as far as making decisions on the file. And then we'll have as a follow-up vendor invoices, the court reporter and the interpreter will send their invoices generally with the transcript, and the interpreter will send it separately. After the EUO, if it's decided that it's either a no-show or that it's going to be denied for a fraud or a material misrepresentation. A blanket or general denial is issued. That is the denial that goes out to all the providers and to the claimant, letting them know that for either their failure to cooperate and appear, or for whatever reasons we need to deny, that goes into the general denial. Now, the general denials and the denials need to be specific as possible. If we're denying it on fraud, we want to give a list or the events or the inconsistencies as to why we're denying. We like to have specific denials as specific as possible. We often can help draft the denial language if that becomes an issue, what to put in there to make sure that all bases are covered. So this way we can preserve this moving forward into litigation strategy. Here is next. We're talking about summary judgment motions, which is this pretty much as an arbitration, a AAA submission. Let's take a quick break here, Christina, and then we'll move on to the litigation strategies.